This meeting is being recorded.
Chair, we are in public session.
Thank you very much, Walt. Good morning, everyone. Welcome to the meeting of the Joint Commission on Public Ethics. The meeting is now called to order. As with all JCOPE meetings being held during the pandemic, we are using video conferencing technology. The public session of this meeting is accessible on JCOPE's website to watch via live stream. A couple of important reminders. It is important that only one person speak at a time. In addition, I ask that you speak, you identify yourself so that we have a clear record. As in our practice, we will take votes via a modified roll call to ensure that everyone is counted. Please also remember to mute your phone when you are not speaking. Mr. Levine, can you please confirm that we have a quorum?
Yes, ma'am.
Thank you. I'd like to take a moment to introduce our new Executive Director, Judge Stanford Berland. Welcome, Judge Berland.
Thank you very much. I'm very happy to be here.
Good. We're happy that you're here as well. Before we move to the first substantive item on the agenda, I would like to take a moment to address one item. What has become clear is that we need rules and order to ensure that the Commission is efficiently and effectively able to handle its business. Several of you have reached out to me on this point over the past few months. To that end, I am establishing a protocols committee to consider and develop recommendations for the Commission. I ask that anyone who is interested in participating, please contact me offline. Moving on to the second item on the agenda, it is the approval of the meeting minutes of the Commission, which you will find behind attachment A. These are the meetings of the public session for the April 27th, 2021 meeting. Are there any corrections to the minutes?
Yes, ma'am. On page 3 of the public session minutes, line 8, Judge Yates has requested that the sentence beginning "the revisions also make clear" would read, "The revisions also make clear that the Commission can publish and modify." Those two words would be added after publish and modify informal letter opinions in redacted form. Judge, have I accurately stated your amendment?
Yes, thank you.
Okay, thank you. Are there any other amendments to the minutes? Okay. Can I please have a motion to adopt the April 27th minutes as amended of the public session of the Commission?
So moved.
Thank you. Is there a second?
Seconded, Fisher.
All in favor, please raise your hands.
Hey, I see Judge Yates, I see Commissioner Horowitz, McNamara, Deering, Judge Newton, Judge Braun, and Albany, leaving Commissioner Cohen.
Yes.
Commissioner DePiero's not here. Commissioner Horowitz, I got. Commissioner JCOPE.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Judge Yates. Motion carries 13, ma'am.
Thank you. Moving on to item 3 on the agenda, report from staff. Judge Berland.
Thank you, Madam Chair. Before we begin the report from staff, I wanted to say a few words and introduce myself to the public. As you know, I'm Sanford Berland, Sandy to my friends and family. I recently retired as a Court of Claims judge and as an acting Supreme Court justice. And I had a long career in private practice and a 2-year stint before that as federal law clerk before my judicial career. My wife Susan and I have 4 grown children, 2 older boys, and we live in Suffolk County. Although I'll be working primarily out of JCOPE's Manhattan office, I plan to be in Albany on a regular basis. I do want to thank the commissioners again for their confidence in me and to reiterate my commitment to carrying out the role of executive director vigorously and even-handedly. The people of the state deserve no less than the assurance that JCOPE is doing everything within its power to ensure that those who serve us in government understand what their ethical responsibilities are and adhere to them. I'm impressed with the caliber and dedication of the JCOPE staff at every level and it is a primary goal of mine to ensure that they have the resources they need to carry out their work efficiently and thoroughly. Further, I want to let the public and the regulated community know that I look forward to meeting with you and working with you. Again, I have tremendous respect for the JCOPE mission and for the work it does, but I firmly believe that to meet our mandate requires a direct and open dialogue, both with those we serve and with those we regulate. To that end, I will be setting up calls and meetings in the coming weeks, but as I've already said to the staff, whether virtually or otherwise, my door is always open, and I welcome comments from all quarters. In short, I'm excited to be here today and eager to meet whatever challenges lie ahead. And with that, I'll move into the agenda with the operations report, which can be found at tab B in the agenda book. Staff is happy to answer any questions, if there are any, with respect to the operations report. As has been previously reported, the majority of staff have been working from home during the pandemic. They come into the office as needed for operational purposes, and I'm confident that staff has continued to be productive. There have been no issues. I would add that ethics guidance calls and tips appear to be returning to pre-pandemic levels, while lobbying inquiries, which spiked with the January introduction of new regulations, are continuing to run at a significantly higher level than in the past. Staff will continue to work from home until after Labor Day to align with children returning to school and more or less the completion of long-planned work on the New York offices. And we'll be developing a plan for everyone to return to the office safely. If there are any questions, staff will be happy to respond to them. All right, let me move on to financial disclosure statements. The 2020 annual statements of financial disclosure were due Monday, May 17. We've received nearly 19,000 filings to date, and the FDS unit will be working on compliance shortly. FDS filings with statewide elected officials have been posted on JCOPE's website. The FDS filings for the legislative branch are first filed with the Legislative Ethics Commission. They'll be submitted to JCOPE by June 30, and the FDS filings for members of the legislature will be posted on JCOPE's website soon thereafter. And that's what I have on the FDS filings. Any questions? All right, thank you.
Okay, thank you, Judge Berland. Moving on.
Commissioner Horowitz.
Oh, sorry.
Sorry, Camille. Chair, Commissioner Horowitz had his hand up.
Yeah, I had a question about the legislative FDS filings. I just want to make sure I understand. So the legislators, they file an FDS with the Legislative Ethics Commission, and then after some period of time, after all the other public officers in the state have to file their FDSs, then the LEC gives us the FDSs of the legislature. Do I understand that correctly?
Yes.
Yes, by law, that's the procedure.
Right. Do we ever get to see what exactly the legislators file with the LEC as opposed to the final product that LEC sends to us? In other words, if a legislator submits something to the LEC and then there are changes to what the legislator gives to the LEC and what we ultimately see, do we ever get to see what those changes are?
Commissioner, the question is, do we get to see the raw original submissions before any modifications or the modification, a red line version?
Yes, that's right, Judge Berland.
I will defer to staff on that. I'm not yet familiar with that portion of the procedure.
Commissioner Horowitz, this is Martin. Whatever might occur prior to JCOPE, we post promptly shortly after we receive them on June 30th every year. But I wouldn't be privy to anything that happened before that.
So if the LEC tells a legislator to make a change in what the legislator gives to the LEC, we don't get to see that, and the public doesn't get to see that either, do they?
I don't think we're in a position to speak to their process.
Do we understand what the public policy is behind that requirement in the law? Not a requirement, it's a exception to the law, as I understand it. What's the public policy behind the legislators sending a raw FDS to an internal legislative body before the public gets to see what the financial disclosure for the legislator is? What's that public policy all about? I don't understand that.
Commissioner Horowitz, this is Commissioner Weissman. I would strongly suggest you go to the bill jacket and see if you can find it.
Well, George, you're a great student of the bill jackets for legislation. Do you know what the public policy is?
I haven't looked for it, so I can't answer the question.
So I'll
Well,
interject.
I don't need to belabor this. I just was trying to get some information since we're talking about FDSs today. I would like to hear from the staff at some point what the public policy is behind this provision of the FDS law. I think it would be helpful for the commissioners to know that. Thank you, Madam Chair.
We would be happy to look into that and report back to you at the next meeting.
Great. Thank you so much.
Can I chime in with one brief comment?
Yes, please. I'm sorry, I can't see who's.
Judge Yates.
Thank
Judge
you.
Yates?
Thank you.
I just remind Commissioner Horowitz that the LEC is equally divided between Democrats and Republicans, so that anyone from an opposing party to the filer would have free and open access to it, and I'm sure would look at it carefully.
Thanks. I mean, I appreciate that, Jim, and I'm sure you may have been on the staff in the legislature when this provision was written, so I'm anxious to hear what the public policy is. I just don't understand why the public doesn't get to see, and I appreciate that legislators are well-intentioned and there's a attention to party parity in the process. I just would like to understand what the public policy is behind any legislator sending something to an internal body before it is made public, when the rest of the people who work in the state have to file it on an earlier date and don't have that provision. And I don't need to belabor it, and I very much appreciate your insight, but I would like to hear from the staff about the public policy. Thank you very much.
We'll look into it and we will report back at the next meeting.
Thank you. Moving on to item 4 on the agenda, which relates to a proposal relating to FDS filer access to information. This item has been requested to be added to the agenda by Commissioner Levine. Thank you. If you'll recall, this is something that we've discussed at previous meetings, and Commissioner Levine graciously allowed us to table, I think at the last meeting, to allow commissioners more time to review his proposal. So Commissioner Levine, I'll turn it over to you.
Madam
Thank you
Chair,
very much.
Madam Chair, this is Commissioner JCOPE. I was trying to comment on the dialogue between Commissioners Weissman and Horowitz with a simple question. Can I do that now or shall I wait? Because I'm talking about something before the resolution of JCOPE that you're about to get involved in. It's just a question of Martin or the people who, or the persons at JCOPE who monitor the FDS filings and how it works at JCOPE.
Apologies that I didn't see your hand. I'm a little visually challenged today.
Well, I'm
fine.
on the telephone. I'm on the telephone, and it's often hard to get into the discussion.
No problem.
Well.
Please ask your question, Commissioner.
Thank you very much. Martin, how does it work at JCOPE? I know that from time to time, commissioners at JCOPE file their FDSs. Staff reviews it because even I have, from time to time, been called by staff about my filing. And perhaps once in the past I've amended it, although I don't remember. But if a JCOPE commissioner files an FDS, staff reviews it, and staff finds some deficiency, calls the commissioner, and the commissioner amends it. Is the original filing by the commissioner available to the public, or is only the final available? How does it work here?
The filings and their amended, and any amendments that might follow are both available to the public. And should a legislator or their staff file an amendment, it would be the same issue. The amended filing as well as the original would be available.
Thank you for the information.
Of course.
Thank you, Madam.
You're welcome. Commissioner Levine?
Again, thank you very much, Madam Chair. Let me emphasize in moving the proposal, the current practice of the Commission renders the Commission an outlier, and it ought to be changed to conform with practice that would obtain under FOIL. Moreover, one or more staff members have access to this information. I believe it's inappropriate that any information whatsoever be withheld from the Commission. However, I do agree with Judge Braun and others who have expressed the view that all filers should have the benefit of this proposal. In moving the proposal, I want to alert the commissioners that the proposal, as I am propounding it today, is retroactive. I move the proposal, Madam Chair.
Thank you, Commissioner Levine. Is there a second? Thank you, Commissioner.
I'll second. Okay.
Okay. So commissioners, the proposal is behind your exhibit. Is there any discussion? Yes.
Thank you, Chair. I'd like to ask Commissioner Levine to clarify something you just said. What I was going to say is that I'm prepared to support this resolution if we can agree that it should apply only to requests for FDS reports made after today, and if there's some sort of notice given to FDS report requesters that the fact of their request may be disclosed to the filer because of this resolution. And when we discussed this at an earlier meeting, I believe Commissioner Levine was in agreement with me on this, but it sounds like when he says this would apply retroactively that he no longer is. I think it's important that we give notice to someone when they file, when they submit a request rather for an FDS filing, that the person that is the filer could receive information about their request. And I don't think we should make it retroactive. And if that is your intention, Commissioner Levine, I would not support this and I would vote against it.
Madam Chair, if I may, I'm in accord with Commissioner Fisher that our practice ought to be that any individual making an inquiry with regard to a filing ought to be notified in very clear terms that their inquiry is subject to being divulged to the filer. However, I do not agree with Commissioner Fisher with respect to restricting the ambit prospectively only.
Okay, so I guess I misunderstood. So the thing that's retroactive is the FDS. So you can request FDS, well, and I don't understand. So let's use an example. Let's say Jane Doe's filing that was made in April. And let's say John Doe makes a request tomorrow for that filing. We're going to notify John Doe that Jane may request information about his request. So, so go ahead, Martin.
I think what Commissioner Levine is saying, and please correct me if I'm wrong, Commissioner, is that requests for an FDS that were made in the past the filer could now, moving forward, ask if anybody had previously requested their FDS even prior to the resolution. I think, is that right, Gary?
Mostly correct.
Okay. Yeah, I don't think that is what we should be doing, because people that made requests before today had no idea that information about their request might be revealed to the filer. And I think they should be given that notice at the time of the request, and therefore only requests after today should be subject to this new policy. So I plan to vote against this because I don't think it's reasonable to make it retroactive for requests prior to today.
Judge Newton?
I think she's muted.
I think you're
She's
muted.
muted.
Again, sorry, good morning all. If I may, I'd like to ask a couple of fundamental questions. One, could someone please explain me the import of a resolution? Is it different from, it's not obviously a regulation, it's not statutory. So how are resolutions, what's the import and impact of a resolution by JCOPE? Is my first question. And my second issue is one of concern about Section 3, about subpoenas and the limitations. I guess I would like to know, how does anyone think that that would work? And do we want it to be something, whether this provision requires more work than should be necessary if there is a law enforcement investigation? So those are two of my questions. And then my third question is that this resolution says that a filer may request from the commission regarding anyone who has requested the filer's information. Yet some commissioners suggest that there would be another automatic feature where anytime someone's file is requested, that filer would be notified. So what is the thinking of how this resolution would operate? Thank you.
Thank you, Judge.
May I, Madam Chair?
Yes.
First of all, Your Honor, you recall that the New York City Charter provides that the City Conflict of Interest Board must take the initiative to notify the filer if an inquiry is made. This proposal would not require the commission to take the initiative. The initiative would be on the part of the filer to ask if the inquiry was made. With respect to law enforcement, it's not the intent of the proposal to interfere with the legitimate considerations that are attendant to a criminal investigation. So this carve-out will provide that the right of the filer to obtain the information will be suspended during some course of the investigation, maybe to the end of the investigation, unless the full commission votes otherwise.
So just a point of clarification, Commissioner. You say that this resolution permits a filer to ask JCOPE, hey, has anybody inquired about my filing? I guess my feeling about that is, how would any filer know to ask that question? And if that's a reasonable response, will we then open a floodgate of every filer just periodically contacting JCOPE for them to interrupt their day to find out if someone has filed for them? It seems awkward if we don't first say that the triggering event should be the asking about the filer's file, and then notifying the filer, hey, this has happened, you may want to ask some more questions. I guess I'm just concerned about which comes first, the chicken or the egg.
Well, it's certainly a very legitimate concern. The object here is in not requiring the commissioner take the initiative to notify the filer is to bring the whole process into a realm of practicality, given we have 30,000 filers. If a filer has some reason or concern, however, this change will permit the filer to take the initiative to ascertain if the inquiry was made.
Thank you.
General Counsel Stan, General Counsel Levine, could you please speak to Judge Newton's first question with respect to the import of it being a resolution?
Yes, ma'am. I think the point of the resolution is that it makes the commission's position memorialized, and I don't know that legally it has any more strength or value than a motion per se, but it also documents the language clearly so that there's no confusion, and it's been used by the commission for different purposes from time to time, but I think as opposed to obviously a clear distinction from a regulation, which is an administrative process, this is simply a memorialized motion.
I'd also ask, and perhaps this has been covered before, yes, well, actually, just right to that point, Commissioner Horowitz, I see your hand raised.
Thank you.
Thank you, Madam Chairman. I am opposed to this resolution, and I want to explain what my concerns are with it, because I think that there are institutional concerns, and I think that in a nutshell, this resolution is completely contrary to JCOPE mission and public policy of ensuring integrity with public employees and the integrity of investigations and inquiries that we conduct, because it stands the process on its head. And what I mean by that is that with an FDS filing, to the extent that a member of the public, whether it's somebody who works in state government, who has concerns about a superior, asking to see the FDS because that state employee believes that their superior is engaged in outside activity that isn't properly disclosed. What this resolution does is it hands to the boss the name of the person who's asked for his or her FDS, his address. It says contact information, telephone number, address, so that the boss knows exactly who it is that's asked for the FDS, can go to that person's house or call them on the phone or send them an email, and then who knows, off to the races with what that boss does to the subordinate. And this turns that process of protecting the public, whether it, again, it's somebody who has concerns about a public official, whether that's a member of the public generally, whether that's another public officer, whether it's a member of the press. We've had this discussion before, and this amendment does nothing to protect a reporter or the news organization's identity from disclosure to a possible target in an investigation. So here's a scenario. The U.S. Attorney's Office for the Southern District is conducting a criminal investigation. Under this resolution, we could say, if they ask us for the FDS, you may not tell the filer that the U.S. Attorney's Office has sent us a subpoena or asked for this information. However, as there often are, there may be news stories about the investigation. Well, if someone from the New York Post to the New York Daily News, the New York Times, or the Albany Times Union calls us up and says, we understand that there's an investigation by the U.S. Attorney for the Southern District, and we'd like Legislator Jones's FDS filing. Of course, that would be the one that is filed with us and not the scratch that gets filed with the LEC. But nevertheless, we would then disclose to the target of the investigation that the Albany Times Union is doing a story and have asked for your FDS. This stands the entire process on its head. And to the extent that somehow the New York City Conflict of Interest Board follows the process that's encapsulated in this resolution, that actually gives me great concern, because the COIB, while it does a lot of good things, the COIB is the agency that gave Mayor de Blasio a pass on the pay-to-play investigations that everybody did, and said it was okay for him to raise the money that he did with the campaign for One New York. So I am not persuaded that using the COIB as precedent is good policy. And again, I understand that this started because there was a thought that the commissioners on this commission should be told when someone requests their FDS. And now the resolution that we see before us is expanded to everybody. That doesn't change the fact that, again, this tilts against our public policy. And so that's why I am going to oppose this. Thank you, Madam Chair.
Thank you, Commissioner Horowitz. Judge Newton, I see your hand raised. And then Judge Bond.
So my question is a simple one. What is the current practice regarding financial disclosure? Can anyone pick up the phone and call JCOPE and say, I would like to see employee Jones's FDS, please let me see it? Or does there have to be a showing as to who you are and why you want to see it and the authority for you to see someone else's filing? I know Monica has her hand up.
Sure.
Yes.
Judge, by law, the financial disclosure statements are available on request, and we have a process in our records access regulations, which the Commission just voted to amend at the last meeting, for how the members of the public should do that. They can submit a written request via email over our website, and then those are processed and logged. But
and the process,
there is no showing. No.
Right. Okay, that was my question. If I'm curious, I can call and get your financial disclosure to see what you got going on in your life. Okay, thank you. And so that's current. And so the question is, do we let that person know that somebody is snooping around in your business? Okay, thank you.
That's the law, yes.
Yes.
Okay, we won't argue with the law. Thank you.
Judge Braun, did you have your hand raised? You're muted.
Bad.
Okay. Thank you. General Counsel Staff.
I'm sorry, I can't hear. Is Judge Braun speaking?
I just said I'm just listening.
Okay, so just two things. One, I just wanted to clarify that, and we can certainly report back on this at the next meeting, but I do believe that the Legislative Ethics Commission gives us both the original filing and then any changes that are made afterwards are handled as an amendment. And again, we can confirm that, but I do believe, I just wanted to correct the record that is my understanding of how this works. And to see if there's any confusion earlier. And then also, just Commissioner Levine, I just wanted to clarify with respect to paragraph 3 of your resolution, so that everyone understands, the exception for subpoenas is only going to apply to what you've characterized as law enforcement subpoenas. So just grand jury subpoenas. It would not apply to civil subpoenas that are issued by other investigative agencies who are conducting investigations that may be relating to a state officer or employee or a private business that is engaging in business with the state. So it would only apply to, is it your position, it would only apply to grand jury subpoenas when you say law enforcement?
Well, Madam Chair, the intent is, and I will amplify on her General Counsel's observation. The object is, if there is a criminal inquiry whence a subpoena emanates, that would be subject to paragraph 3.
Thank you. I see Commissioner Horowitz.
So, Madam Chair, if I understand then, if there was a request by an inspector general, let's say for the MTA or the Port Authority, or State Inspector General, or the New York City Department of Investigation. This resolution, item 3, the carve out for law enforcement, wouldn't apply to an inspector general's investigation?
Madam Chair, it's contemplated that within the ambit of law enforcement, the Inspector General's activities would be included.
I mean, look, I've said that I'm opposed to this, but for the sake of, good order, law enforcement is actually a defined term, for example, in the penal law. And some of those agencies have law enforcement responsibilities, and they have extra responsibilities that go beyond that. So I think that to the extent that if this passes, and I hope that it doesn't, but if it does, there ought to be some clarification on what exactly law enforcement means, so there isn't any confusion. As I said, when, for example, who knows, the Construction Authority IG calls up and asks for an FDS. That it's clear that that's an agency that's covered. Thank you.
Thank you, Commissioner Horowitz. Is there any discussion before I call for the question?
Yeah, I have a question. And it's really directed with staff, Commissioner Weissman. Would the request for contact information under paragraph 2 come within the ambit of an unwarranted invasion of privacy under the Freedom of Information Law?
We'd have to, I personally would have to do the research. I haven't, I don't know the FOIA exemptions well enough to speak to that specific question, but we can.
Because that was all the things Commissioner Horowitz raised. That's the one thing that struck me as truly of concern, and maybe the language in paragraph 3 that may need to be shown up to a certain extent. I don't know if this is appropriate, but I'd request Commissioners Levine and Yates to withdraw their motion so we can sort through some of the other legal issues that have been raised here today.
Commissioner Levine? Are you willing to withdraw the motion at this time so that we can research these additional issues and bring it back at the next meeting?
Yes.
Thank you.
Madam Chair, this is Commissioner JCOPE. May I ask a question?
Absolutely.
I'd ask this of staff who handle the requests that are made from the public to access the FDS filings. And this is based upon your experience. Do persons who request FDS filings request that their names not be divulged, request anonymity? Do they demand it? What is the experience of the staff when these requests are made?
Right, that's an issue. I think we'll have to survey staff on intake on whether specific requests are made. The current practice would not be to divulge the identity of the requester. So those who are sophisticated enough to understand current practice would likely take on that protection, that safeguard. It may be that some individuals express the need for it, but we'll have to survey staff to find that out. I would ask that we'll also look at the volume of the request, as well as point raised by Joe as to if we're not going to be informing filers the request or what kind of volume we expect of standing requests, closure of requests by the tens of thousands of individuals who file FDS. report.
Um,
Hard question.
Madam Chair,
Yes.
to the chair. I made this suggestion last time and I'll reiterate it. Instead of reinventing the wheel, the exception should track FOIL. You should cross-refer to Public Officers Law 87, which has a broad range of exceptions that would cover most of the things that Commissioner Horowitz was concerned about and that Commissioner Weissman expressed some concern about, including invasions of privacy and ongoing law enforcement proceedings, et cetera, et cetera. I think the simplest way to do this is don't reinvent the wheel. Just look at, and whoever's doing the redrafting, whether it's Commissioner Levine or staff on behalf of him, just look at 87 in the Public Officers Law and cross-refer to it.
Thank you.
Madam Chair,
Yes.
Commissioner JCOPE here. I'm
Yes.
on the telephone, and there's a lot of noise. Maybe it's because people are not muted, but it's difficult to hear. I don't know whether others are having the same experience who are on the phone, but I find it very difficult to hear what is happening.
I was actually just going to address it. I believe that someone who is on the phone is not muted. And so we would absolutely ask that if you haven't been called upon, if you can just mute your phone. It actually has gotten quiet now. So hopefully,
yes, it is quiet.
Hopefully that'll be better.
It works.
Yes. Okay. So
Chair, just one final question, just to get the facts out. I don't know whether this has been stated before, but what is the volume of requests to access FDS filings? How many of these come in a month, a year? What are we dealing with here in terms of volume? Perhaps staff can look at that as well and get that.
Yeah, we'll look at the question of volume.
And I think Judge Berlin posed the question of capacity to address these additional requests that potentially would come in. General Counsel Stam?
I just wanted to point out that in the monthly operations report, at the very last page, we've been reporting on this on a monthly basis and the year to date. But my understanding is that now that they've just been filed, so that this is obviously the last month's report, but when they're filed, we get a huge uptick in requests. So Walt and the staff that process FDSs are dealing with those now. So these numbers will take a big leap for the month of May. And then they also will take a big leap in the month of November when we get the academic filings. So this is always included the monthly operations report, so we will have it at the next meeting. You can see what the May numbers look like.
Thank you,
Mark. Moving on to our next item on the agenda, it relates to the Governor's Executive Orders 202.6 and 202.7. Before we begin conversation on this item, Commissioner Levine, you asked that it be added to the agenda. I would ask that you consider moving this item to executive session. My understanding is that this proposal relates to the potential issuance of subpoenas, and my general understanding of how the commission is operated, we don't generally have those conversations in public session.
So thank you, Madam Chair. I have asserted before and maintained the proposition at this meeting that the request is for an informational subpoena and that the discussion should be in the open session.
Please proceed.
May I have a point of order, please?
Yes, Commissioner Horowitz.
Thank you. I'd like somebody on the staff to explain what the difference is between a quote-unquote informational subpoena and an investigative subpoena, and what the support is in the public officers law for the distinction, because I am very confused and highly skeptical that there is something called a quote-unquote informational subpoena. I'm just not familiar with that concept with an investigatory body like ourselves. Thank you.
Thank you, Commissioner Horowitz. General Counsel Stam or Deputy General Counsel Levine, if either of you could speak to that point. Yes,
So,
General.
To Commissioner Horowitz's point, there is no distinction between one type of subpoena and another. We'd be issuing a subpoena pursuant to our authority under 9417C, which, as I think most of the commission is familiar, but it says that the commission shall have the power and duty to, in relevant part, conduct any investigation necessary to carry out the provisions of this section. Pursuant to this power and duty, the commission may administer oaths or affirmations, subpoena witnesses, compel their attendance, and require the production of any books or records which it may deem relevant or material. So that would be the power under which we would exercise the authority to issue a subpoena. And obviously, if we were challenged on the subpoena, we would have to establish that we had a good faith basis to issue the subpoena. But there is no distinction between an informational subpoena and any other subpoena that we would issue.
Thank you, General.
I guess, Madam Chair, I support your suggestion that this issue be taken up by the commission, but that it be done consistent with the law, which requires a discussion like this to be held in executive session. And I am fearful that any departure from that process will create a dangerous precedent for us to begin to have discussions in the public session for what is rightfully to be conducted and lawfully to be conducted in the executive session. So I am really unsure about the basis, the legal basis for our proceeding at this point in the public session with this application.
Thank you, Commissioner Horowitz. And I certainly agree, especially based upon the clarification that General Counsel Stam has just made. And I would move that we move this item to discussion in today's executive session of the meeting. Is there a second?
I would second that.
Thank you. Is there any further discussion on this point, on this motion? All in favor?
Okay, in Albany, I have Chair Morlack and Commissioner Fisher. See Commissioner Horowitz, McNamara, Judge Newton, Commissioner Deering. That looks like it. I'll call the remainder. Judge Braun.
Oh, you're muted. Judge Braun.
No, I had trouble before mute button. No.
Okay. Commissioner Cohen.
Yes.
Deering, Commissioner JCOPE.
Can you repeat the motion again? I had trouble hearing on the phone.
Yes, Commissioner. The motion is to move the discussion of the item to executive session.
The answer is no.
Thank you. Commissioner Levine?
No.
Judge McCarthy? I believe we lost Judge. Commissioner McNamara, I saw your hand. Judge Newton, I saw your hand. Commissioner Weissman?
No.
Thank you. Judge Yates?
No.
Thank you. And Chair gives me 1, 2, 3, 4, 5, 6, 7 in favor. Motion fails, ma'am.
Okay. Commissioner Levine, please proceed.
Thank you, Madam Chair. With the legislature now considering fundamental changes in ethics administration, out of the hub of Executive Order 202.7 spoke some very important implications for ethics administration. First of all is the question, what constitutes status as a public officer? I would note in the Percoco case there was extensive attention paid by the court to the question of when Mr. Prococo was functioning as a public officer and when he was not, for purposes of federal law. We have in 202.7, since rescinded by joint resolution of the legislature, a variation on the theme. What circumstances and characteristics render an individual who's a supposed volunteer as a public officer or is not a public officer? 2, there's an opinion of the Attorney General which requires that volunteers be supervised by state employees. But when the executive chamber made its FOIL response, it stated it had no relevant records. So the response by the records access officer of the chamber is either a fabrication, which itself is unethical, or it indicates nonfeasance on the part of the administration. Likely, one or more of the senior level volunteers are not volunteers at all. They are being paid, or they were paid before the rescission of the order, by their employers who may have substantial business with the state. Plausibly, among the volunteers were those who were politically involved, including soliciting campaign contributions. Now, participating in politics is their prerogative, so long as they do not exploit their de facto public officer status. As I read the executive order, Madam Chair, the volunteers had and continue to have the benefit of substantial exemption from compliance with the public officers law, but appear to have and continue to have the benefit of public officers law sections 17 and 19, which provides legal fees in civil and criminal proceedings, which, given current circumstances, may turn out to be a very important consideration. The one aspect of ethical compliance which is explicitly addressed by the former executive order is a conflict of interest protocol. However, so far as I'm aware, the executive chamber has refused and continues to refuse to disclose how this compliance has been enforced, if it's been enforced at all. Volunteers are not subject, as I understand it, to post-volunteering employment restrictions, which raises, again, a significant ethical question. Indeed, there are many questions posed by Executive Order 202.7, and so far there have been very few answers. With the legislature undertaking its review, I believe it's incumbent upon us to participate in that deliberation of what reforms should be made in ethics administration, and we cannot offer an informed viewpoint in the deliberation unless we have information about how this order was administered. Under the executive law, I will reiterate, it is our responsibility to advise with respect to ethics administration in the state. And I believe it's important that we have this information so that we can meaningfully contribute to that discussion, and I move the proposal.
Commissioner Levine, can you just be very clear so that we all know what we're considering, exactly what your proposal is?
Yes, Madam Chair. I am proposing, and we can be polite about it, of course, that we ask the executive chamber for, 1, a list of individuals who are within the ambit of the executive orders. 2, who in the executive chamber administered these executive orders and compliance with the opinion of the Attorney General with respect to supervision of so-called volunteers. A list of persons who are literally volunteers or were literally volunteers within the ambit of the executive order and a list of those who were considered volunteers but who were actually being paid by their employers. Any recusals with respect to the individuals identified. Any instances in which gifts from interested sources were given to individuals identified. And lastly, any vendor which did business with the state under emergency provisions, which exempted them from regular procurement process if the value of the contract is $1 million or more.
Thank you, Commissioner Levine. Is there a second?
I'm not seconding. I have a question about the language. We talked a few minutes ago about what kind of subpoena this amendment, this motion is calling for. I think that needs to be in the motion. We need to know whether this is an investigative subpoena, this is an administrative subpoena. Is this subpoena being issued pursuant to Section 17C or some other part of the law? I think this motion needs to have that degree of specificity in it, Madam Chair.
Commissioner Levine?
Yes. Thank you, Commissioner Horowitz, for your observation. It is certainly not unprecedented in administrative agencies to issue subpoena to glean information for the purposes of establishing policy or advising on policy. The purpose of this subpoena is not investigatory. It is to glean information so that the Commission may make an informed contribution to the discussion about ethics reform in the state.
Thank you. Is there a second? Okay, Commissioner Weissman, thank you. Is there any additional discussion? Commissioner Fisher?
I plan to vote against this. As someone who believes in limited government, this is a great example of overreach. This commission can express its opinion and ask the legislature to look into an executive order and rescind it. There's investigative journalists that can journalistic, but this has nothing to do with any of our powers and duties. And therefore, I'm going to vote against it.
Is there any, Judge Yates?
Thank you. This has been ongoing for several months. And the genesis of this, for those who are not familiar with the history, is the following. The executive law allows the governor during an emergency or a disaster to go ahead and suspend certain laws. He can do that on certain conditions, and that is it has to be reasonably necessary to aid the disaster effort, and any suspension needs to provide for the minimum deviation from the requirements of existing statutes which are being suspended. If you look at 202, the executive orders, both 202.6 and 202.7, they say that ethics laws, disclosure and conflict of interest laws, Public Officer Law 73 and 74, are suspended with regard to anyone who's a low-paid, a volunteer or a low-paid person. We've asked the question repeatedly. This might be the fourth month in a row when I've asked the question, and that is, suppose somebody is invested with the authority of a state officer or a public officer to wield great power during this emergency situation, and that person acts in conflict. For instance, awarding a contract to a family member or to as a political favor. Is there no way that we can look at it? So the simple question that Gary and I and a couple of other commissioners have asked over and over and over again is, if there's a conflict, can we, an ethical violation, are we empowered to investigate it, or has the governor's executive order divested us of any authority to look into the conflict, to examine the misdeed or corruption? In order to keep it simple and informal, on a couple of occasions, Commissioner Levine asked staff, would you please reach out to the second floor, to the governor's office, and find out what the scope of the impact of this executive order is? How many people are affected and what powers do they have, just so we know who's out there and whether or not they're covered. Now, at one point or another, in one of the responses that we received, we were told that the ethics laws don't apply because, oh, they're not state officers, they're not public officers if they're volunteers. Well, that's clearly wrong. Commissioner Levine was talking about an attorney general's opinion. You can actually just look at the public officers law, the definitions in section 2 and thereafter. And then anyone who is invested with the authority of the state is by the governor and appointed to and empowered to perform certain functions is a public officer. You don't become free of ethics laws just because you say, oh, you know what, I'll give myself a contract, but don't pay me a salary. It doesn't work that way. So the question that we've been trying to get to for the longest time is, do we have the authority as the JCOPE to look into and hear complaints about conflict of interest or misdeeds or corruption just because somebody has popped in and said, oh, I'm acting on behalf of the governor, but by the way, I'm not being paid. And that's what this is all derived at. The response that our staff, reportedly, that our staff got when they reached out to the governor's council or governors of the second floor was, being polite, was basically none of your business. So the thrust and the point of this subpoena is to find out what the scope of our authority is, period, and what the impact of the suspension is, period. That's not an investigative matter. We're not looking into any one particular case. We're asking an administrative structural question, and that is, are the rules suspended for people who are empowered by COVID because of 202? Now, the last thing that I'll say, I've gone on and I appreciate you giving me the time to say this, is the way the executive law works is that a suspension by the governor during an emergency is in effect unless by resolution the legislature withdraws that power. So the question that Commissioner Levine's motion puts in the public forum is an essential and vital question. And that is has JCOPE been divested of power to look into complaints about corruption? And if so, shouldn't the legislature know that so that they can take the power that they have by resolution to limit or adjust that exemption? Thank you.
Okay, we've got a couple of hands.
Yeah, let me just say in response to that absolutely we have the authority to look into complaints. I don't think that there's any question about that. The other side of it is whether we have the authority and the resources to go off in a different direction, seeking information, essentially, if I understood correctly, at least partly for educational purposes, so that we could learn whether there's some sort of issue that we might be able to address through educational means, through some of the processes we use there to inform state actors of what their ethical responsibilities are. But those are two very different courses of action.
I'm sorry, I have to jump back in. I couldn't disagree with you more. The plain language of the executive order says that Section 74 is suspended for people who are covered by that order, period. If Section 74 is suspended, then with all deference to, I would like to see a written opinion, either from council or from the second floor, explaining to me why a suspension of Section 74 of the Public Officers Law means we still have the power to investigate. Thank you.
Thank you, Judge Yates. It's Commissioner Horowitz, then Commissioner Fisher, and then Judge Braun.
Thank you, Madam Chair. For a group of commissioners that is committed to the rule of law, I am highly disturbed by the deviance from what the law requires of us. The issue is not whether the chamber gave us an obnoxious response to an informational request. That is not what this issue is. This issue right now is whether this commission has the legal authority under Executive Law 94 to issue this subpoena. I am not passing judgment on whether or not it was obnoxious for the chamber to blow us off, if that's what they did. We are not, our authority is defined in Executive Law 94 for subpoenas. In Section 13A under investigations and in Section 17C, where we can issue subpoenas to conduct any investigation necessary to carry out the provisions of Executive Law 94, Section 17. There's nothing in the law that gives us plenary authority to issue an administrative subpoena in the way that Gary said that we have the authority. And I appreciate what Jim Yates is trying to do, which he's trying to explain that, look, we have good reason for asking for this. Gosh, we asked for this information and the chamber blew us off and we really should get it. Well, that may be, but we should do that with the legal authority that we have under Executive Law 94 to conduct an investigation and issue a subpoena, which we are authorized to do under Executive Law 94, mind you, in an executive session. And so again, I come back to what I said at the beginning, which is for a group of people who honestly are committed to the rule of law, this is an application that deviates from that, notwithstanding whatever we feel the chamber did in terms of responding to an information request. At the end of the day, the legislature and the executive branch created Executive Law 94, and we're stuck with it, whether we like it or not. And we should follow that rule. So I'm going to vote against this for that reason, because I don't believe that the way that this amendment has been proposed, again, it's not going to the substance of the amendment, it's going to the process. The process does not have legal basis. If this amendment was brought up in the executive session, I would not be making these points. But because a majority of commissioners decided to proceed in the public session, this amendment is without authority. And if it's agreed to, it's my strong view that this is contrary to the law. This amendment, if it passes, will be contrary to the law and will be without legal basis in the law. Thank you, Madam Chair.
Commissioner Fisher.
Madam Chair, with all due respect to my friend Commissioner Yates, I wanted to correct the record. At least as far as I know, the staff has not told us that volunteers are not subject to our jurisdiction. In fact, they've told us the opposite, that if there's a person volunteering, let's say at the New York State Department of Health, who's in a policy-making position, it's the responsibility of that department when they submit their list of their people who are subject to FDS to include that person, regardless of the fact that they don't make any money. I requested a list of the Department of Health employees, and there's right around 500 people on it. Many are above a limit, a salary limit. Others, though, are below the limit but are named because they are in positions as policymakers. And my understanding, and I'll ask General Counsel Stam to confirm this, is that volunteers who are in policymaking positions need to be on that list of people that are subject to our jurisdiction and must file financial disclosures.
Okay, so we do have a list of commissioners that need to speak. So I'm going to ask Judge Braun and then Judge Newton to speak, and then General Counsel Stam, I'll ask if you can respond to Commissioner Fisher. Judge Braun?
Thank you. Directed to Commissioner Levine, could you restate the portion of your resolution motion that relates to recusal and elaborate for all of us on the basis for your including that?
Yes, Your Honor. 202.7 has an allusion. It's somewhat cryptic, I'll characterize it, to recusals involving volunteers. But the order, as I interpret it, does not delineate or enumerate the process by which these recusals will be made. Who monitors compliance with the recusal? And the executive chamber won't divulge this information either.
Thank you, Commissioner Levine. Judge Newton?
Yes, I have several questions, and I appreciate the various positions and the backgrounds, but right this moment, I have one specific question and may want to tag on to what Judge Yates said about a writing an opinion from staff to clarify it. I think I've gleaned an understanding that the relevant statute says that we can issue a subpoena and that it doesn't differentiate between the type of subpoena. Doesn't say there's a informal or formal, it just says subpoena. And my question is that it is attending to the notion that the subpoena should be issued when there is an investigation. And I guess as still the newbie on the commission, the new member, whether or not the kind of subpoena with the focus offered by Judge Yates and Judge Levine is sufficient to call it an investigation. So my question is, do we have to have an investigation voted on in order to issue the subpoena? And that's strictly for a legal question in my mind, and I think it's important to have the answer to that, notwithstanding the very strong feelings that people have about whether this matter in general should be looked into, whether we have the legal authority. Is this an investigation? Are we opening an investigation? Is this a subpoena? Will our subpoena withstand, have the specificity that's necessary from a legal point of view and not be considered just sort of, we're interested, we want to learn a lot so we can do our job better. So those are legal questions I think that we need to at least consider having answered before we complete this vote. Thank you.
Thank you, Judge Newton. General Counsel Stamp, there have been several issues raised, including the communications with the chamber. I'd ask you to comment. We can't hear you.
Sorry. So just to clarify, despite the fact that the commission has discussed this multiple times in the public session, there haven't been multiple communications with the chamber about this issue because many of the discussions in the public session have resulted in votes that didn't carry. So I don't remember the specifics at this point in time, but early on when this issue was first raised by Commissioner Levine, he asked for information similar to what he wants to request now by subpoena. And the direction I received from former Chair Rosen at that time was, we'll contact the chamber and find out whether or not they have a process, but not going into all the specifics of the questions that have been raised by Commissioner Levine now. I had a discussion with the chamber at that point in time, and they responded that if there were specific allegations relating to any individual violating the public officers law, that they would cooperate with that request. But with respect to other requests, what I'm going to characterize as informational based on what how Commissioner Levine has made his request, they asked what the commission's authority is to make such requests. And again, I reported that back to the commission. There's been multiple discussions, but we never got back to the chamber because votes to do so never carried. And so we never responded with our legal authority for making such a request, whether in orally, in writing, or by subpoena. As Judge Yates has said, we have discussed multiple times whether or not there's anything in the executive order that would prevent us from conducting an investigation, or whether or not the executive order would just give someone a potential defense if we were to conduct an investigation. So that question has been discussed, and I understand Judge Yates' position. I don't see anything in the executive order that precludes us from conducting an investigation, but I think, as Judge Newton said, and also Judge Yates, this should be addressed by legal staff, could be addressed by legal staff. Again, that should be done in executive session if we're going to talk about our legal authority and send the legal challenges to our legal authority. We currently have 2 ongoing civil litigations relating to how we've exercised our subpoena authority. And so this should be discussed in executive session. As to the issue with respect to volunteers, and Commissioner Yates and I have discussed this also in the public session multiple times, we have precedent that makes clear that in some circumstances, volunteers will be subject to the public officers law, and there's criteria for that. Same for certain independent contractors may be subject to the public officers law if they meet certain criteria. Not all volunteers, not all independent contractors. It depends on the authorities and the powers and duties that they're exercising. So then to Commissioner Fisher's question, which relates to whether or not an individual has to file a financial disclosure statement, it turns on whether or not the appointing authority has determined that that person is a policymaker. And that, by law, is a determination of the approving authority that's set forth in Public Officers Law 73-A. So if the appointing authority determines that the individual is a policymaker, they are required to identify that person to us, and we add them to our system, and they're required to file an FDS. In addition, obviously, individuals who make over a certain salary also have to file. I think I've answered many of the questions, but I'm not sure if I answered all of them, and I'm happy to answer more.
Can I proceed with a question then, or with? Okay. Actually, 3 or 4 points that have been raised. Thank you, Monica, for some of the clarification. I couldn't agree with you more when you say that in the past, the law and practice has been that even if you're a volunteer, the ethics laws apply to you. I agree with that. And apparently you agree with that. The concern here is that the executive order put out by the governor says, oh, by the way, because of the emergency, I'm suspending that rule. So the issue is not whether or not a volunteer is covered. The issue is whether or not the governor has overbroadly under Executive Law 29A, because it's not necessary to handle the emergency and it's not a minimum deviation, whether or not he suspended the law and the practice, which is that the ethics rules do apply. That's number one. Number two, in the answer that you were just providing, which was very helpful, people have conflated and confused Section 73 with 74. 73 is the requirement to file a financial disclosure form, and it's true that the employers can, I think Commissioner Fisher pointed this out, and you did as well, Monica, that under 73, that an employer can designate someone as a policymaker, and we have a list for those people. But that only applies to financial disclosures. My concern from the beginning has never been about financial disclosures from volunteers during the pandemic. My concern has always been about conflicts, whether or not there's corruption, self-dealing, whether or not people are wielding power in an unethical way merely because they're volunteers and the governor has said, I'm suspending that law. That's number two. Number three, I've heard from staff conflicting responses here so far on the core question, which I think it was Commissioner Fisher raised, and that is whether or not today we may investigate a conflict. Because I think, I couldn't tell because it's a phone number and not an image or whatever, but I think I heard the Executive Director Berlin say, oh, clearly the ethics laws are not suspended with regard to the volunteers. Well, I don't see that, and I agree with everybody, I think, Judge Newton and everyone else, who said, yes, we should get that in writing, either from the second floor or from staff itself, because if that's the rule, and we're not disempowered by the governor's executive order, then I'm happy. and I would just put aside this whole concern. The problem is, I don't believe that's the rule, and I don't read it that way, and I hear conflicting answers from different people, so I would like to have clarity on that issue. And then finally, with regard to the last point that Monica, I hope you don't mind me calling you Monica throughout. We're friends, so I do that, okay? Council Stab has raised, with regard to the last point, you raised an excellent point that gives me pause about the prior vote. And that is, I voted to have this discussion in public because I thought we were talking about the scope and power and administrative structure of the agency and not about any particular investigation. But you do raise a good point, and that is if you think that that a memo and a legal discussion is going to rely upon advice of counsel to the commissioners, and we're going to have an internal legal decision based on that, then I do agree with you, Monica, that that particular discussion should be an executive session.
Let me just clarify, Judge Yates. What I was saying was we clearly have the authority to investigate in response to complaints. The broader question was whether we have the resources to engage in a broader pursuit, and that's something we really need to look at. I was not reflecting on the question of whether or not the governor had the power through executive order to supersede our jurisdiction under Section 74.
Well, if some empowered public official has gone ahead and done something wrong, either politically or ethically, and you're telling me, and there's consensus here, that we can go and pursue that, then I'm happy.
So,
Madam Chair.
Yes.
Madam Chair, this is Commissioner JCOPE. Just wanted to make one point when you're prepared to recognize me.
Please, go ahead, Commissioner JCOPE.
I respectfully submit that there's been a serious misreading of Section 17. Commissioner Horowitz has advanced at several meetings the notion, and staff has as well, that the only subpoenas we can issue are investigative subpoenas. This is not literally what Section 17 says. Section 17, if I may, in addition to any other powers and duties specified by law, the Commission shall have the power and duty to promulgate rules. So that is 17A. And 17C says to conduct any investigation necessary to carry out the provisions of this section, not of the entire chapter. In other words, what Section 17 seems to be designed to do is empower the Commission to issue subpoenas so it is in a position to promulgate rules. That's what 17 says. And it's just being read very broadly, and I believe, I submit, incorrectly. So the notion, and I said this the first time the subject came up, having served at other agencies, albeit federal, we conducted studies, we promulgated rules and regs, and we issued subpoenas to collect the information so we could intelligently do that. And that's what 17 seems to be about. We promulgate rules in the lobbying area. And if we need information, we're empowered to subpoena that information. That's an informational subpoena. It has nothing to do with investigation. And the notion that we have no authority to issue informational subpoenas is clearly contradicted by Section 17. Section 13 and our investigations, and 13 speaks about a subpoena plan, Those are investigations. 17 is redundant if it means that. We already have the power to issue subpoenas to do investigations. But this gives us the power to do studies if we need them, to assist the legislature to legislate, to assist ourselves to regulate through rules and regulations. So it clearly says, conduct any investigation necessary to carry out the provisions of this section, meaning section 17. It doesn't mean section 13 or 14. So I again submit, as I did the very first discussion, that every agency has the authority to issue informational subpoenas because agencies regulate, they promulgate rules, they promulgate regulations for comment. They haven't got the power to get the information, and it's all out there. They can't carry out their work, and that's what I believe 17 recommends. So 17 says. So what Commissioner Levine is talking about, an informational subpoena, is not something alien and unheard of, not done. It's done everywhere, all the time. I was at an agency of the federal government for years. We did it all the time. So I again submit that 17 should be read as it is written. And informational subpoenas make a lot of sense. And the legislature thought so and put it into 17. Thank you.
Madam Chair, I feel compelled to respond to what Commissioner JCOPE just said. I mean, look, let's come to the bottom line.
I don't know.
May I finish, please? Because nobody interrupted you, and I want to just have the courtesy of being able to respond, Marvin, as you would give the courtesy to everybody. So I'll just proceed then.
Hold on. We have two commissioners speaking, which is going to be difficult for purposes of making sure we maintain order. Commissioner JCOPE, I thought
you ask people to identify themselves. I'm on a phone. People talk. I don't know who's talking. I was merely asking the person who was talking to please identify himself or herself. Is that too much?
No, not at all. I was actually going to acknowledge Commissioner Horowitz for that very purpose. So, Commissioner Horowitz, please proceed.
Thank you, Madam Chair. So as much as Marvin would like to still be at the SEC from 40 years ago, JCOPE's not the SEC. It has a completely different set of enabling laws that give it a whole broad range of authority that has zero to do with what we do. Now, looking at Section 17, the fact is that in 17C, there's a word, and it's investigation. And as much as you want to substitute your judgment for the judgment of the professional staff, our general counsel, you can't get away from the fact that the statute has the word investigation in it. Now, to the extent that you say that we have the authority under 17 to promulgate rules on outside activity and limitations on the receipt of gifts and honoraria by persons subject to our jurisdiction, the way that this motion has been framed by its author and by a number of people who have talked about the conduct of the chamber and trying to find out what the chamber did with volunteers and whether volunteers were in compliance with what would otherwise be their requirements, that all smacks of something that has nothing to do with our issuing a new rule. I mean, as I understand it from the author, the purpose of this is to gather information. We're not about to issue a new rule because, again, Marvin, going to the plain language of the statute, it says promulgate rules concerning restrictions on outside activities and limitations on the receipt of gift and honoraria by persons subject to its jurisdiction. That's what, if you're going to limit this 17 to that purpose, Well, I haven't heard anything about rules. I've heard questions about conduct which go to the kind of investigative activity that we engage in to find out whether there have been violations of the law. So again, that's my basis for believing, in response to you, Marvin, respectfully, that this motion is contrary to the law, is not authorized by our law, not the law that enables the SEC to do what it does, but our law. And so I don't think the motion is legally appropriate. And I think that if the commission votes in favor of issuing this subpoena, it will be a subpoena outside of the law. Thank you. And thank you, Marvin, for giving me an opportunity to respond. And I'm sorry that I didn't identify myself. I forgot that you're on the phone, and it's hard to figure that out. Although you and I have known each other for such a long time, I guess I just assumed you'd recognize my voice. But anyway, thank you. And thank you for giving me the courtesy, Marvin.
Thank you. I would just ask the chair to just briefly respond to you. That I am saying there is nothing to suggest that Commissioner Levine's motion does not direct itself as well to the promulgation of rules. If there is a legislative provision out there, 29A, and there are executive orders such as 202, et cetera, that happen during disasters and emergencies, who's to say the commission should not today, tomorrow, be promulgating rules as to how these things are to be conducted, so that there aren't the kinds of disputes we're talking about now. We're not ousted of promulgating regulations. So if you just look at 17C, and it's all Gary is asking, maybe we want to do regs about this, and I want a subpoena issued for that purpose. That's exactly what 17 says. That's my simple response to you.
Thank you, Commissioner Jacob. Commissioner Fisher.
Madam Chair, I have a couple of questions for staff, and since Martin's right here, I'm going to ask him rather than Monica, just because it's easier that way. So we understand the language of the resolution that Commissioner Levine read. Would this apply to healthcare professionals offering their medical services on a voluntary basis?
I don't want to speak for Commissioner Levine, but it would seem to include any volunteers under the executive order, which talked about assisting with the COVID response.
Okay. And would it apply to volunteers working at the testing centers and the vaccine centers? I know in Onondaga County, we have volunteers at all of those places that are contributing their time. Most of those people have jobs, so they have employers. Would those volunteers at the pop-up centers and the testing centers have to be on this list that we're looking for of volunteers that are exempt from certain provisions of 73 and all of 74?
Until the executive order was rescinded, I would think yes.
So that could be well into the thousands, if not over 10,000 people that have volunteered as a medical professional or volunteer at a clinic or a vaccine center.
I don't have any information on the volume.
So, Commissioners, thank just one brief moment. Thank you for the discussion, the robust discussion on this point. I just wanted to note that there clearly seems to be a state of unreadiness, at least for some commissioners, with respect to a whole host of issues, several of them being legal. And there was mention that it would be helpful if there was, or that it perhaps would be helpful if there was a legal memorandum that perhaps addressed some of the specific issues that have been raised by commissioners on this call. Commissioner Levine, I would ask whether or not you would consider tabling your motion for purposes of the legal staff putting together such a memo, which could perhaps be illustrative to the commissioners on some of the points that they've raised.
I don't accept the premise, Madam Chair, that What we do with the information is germane to the vote today, number one. I've stated previously, and I will repeat for emphasis, it is certainly plausible that information would be turned over to us that would prompt an investigation. In that second phase, obviously, that would be confidential under our statute. It is certainly the case that information that should be otherwise redacted should be scrutinized by staff and the commissioners and appropriate redaction taken. But nonetheless, there is no question, in my view, no memorandum is required. It is the inherent institutional prerogative of the commission to issue an informational subpoena. Therefore, I will not withdraw today's motion.
Okay, I call the question. All in favor of the motion, please raise your hand.
In Albany, I see Commissioner Weissman. On the screen, I see Commissioner McNamara, Judge Yates, and Judge Braun. I'll call the remaining roll. Commissioner Cullen.
No.
No. Commissioner Deering.
No.
Commissioner Fisher.
No.
Commissioner Horowitz.
No.
Commissioner JCOPE.
Yes.
Commissioner Levine.
Yes.
Judge McCarthy.
Yes.
Judge Newton.
No.
Thank you. Commissioner Weissman, you voted in favor. Judge Yates, I apologize. I already forgot. Can you?
I think that was a thumb.
I said yes.
Thank you, Judge. I apologize. And Chair Barlack?
No.
That's 1, 2, 3, 4, 5, 6, 7 in favor. Motion fails.
Thank you. We are now at the new and other business of the agenda. Commissioners, do we have any?
Yes, Madam Chair. And then I have a question for staff, and then I have a motion to make. The two different subjects. The question deals with the deliberations of the Confidentiality Committee. Would staff indicate to the Commission what is the timetable for resolving the myriad of other substantial issues with respect to confidentiality?
So, Chair, if I may? Sure. Yeah. I don't think that there is a clear timetable. There is an issue pending that has been on the executive session agenda that the Commission hasn't been able to get to. And then there are remaining issues that the Commission has to address that the committee has made recommendations on. But again, the Commission needs time in executive session to discuss these issues. So they're ready for the Commission to consider, but the Commission needs time in executive session to address them.
Well, on the follow-on, Madam Chair, if I may address Madam General Counsel, is the staff considered, for example, whether the confidentiality provision of the executive law obtains if one or more commissioners are subpoenaed by one or both houses of the legislature to testify, as the Senate has indicated they intend to do?
I would like, if you want me to address that question, I'm happy to address it. We could do it offline or we could do it in the executive session, but I'm not prepared to answer that question in the public session.
Thank you very much. I will pursue that question, Madam Chair. Now to my resolution, if I may, Madam Chair. I propose henceforth the executive sessions be recorded and that the deliberations be transcribed.
Okay. Is there a second? Okay. Commissioner Weissman has seconded the motion. Is there any discussion? I believe, I'll just start by saying, I'm establishing a rules committee, and I think that, that the conversation with respect to the reporting of executive session certainly should be referred to that committee for discussion. At minimum, I think it should be discussed in executive session because there are potentially legal issues with respect to our changing our current procedure. Is there any other commissioner that has a point that they'd like to make on this matter? I don't see any hands raised. Anybody on the call? Okay. Commissioner Levine, would you be willing to move the discussion on this point to today's executive session?
On the proviso, Madam Chair, that the result of the deliberation is in the public domain.
I'm not going to commit to that because I don't know what the decision is going to be.
I will not withdraw the proposal.
Okay. I call the question. All in favor?
Okay. I see Commissioner Weissman in Albany. Judge Newton. That's it on screen. I'll call the remaining roll. Judge Braun.
No.
Thank you. Commissioner Cohen?
No.
Commissioner Deering? Sorry, Jim, we missed that.
No.
Thank you.
Did you hear me? Yeah.
No.
Thank you. Commissioner Horowitz?
No.
Mr. Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
Commissioner McNamara?
No.
Judge Newton, Commissioner Weissman, you voted in favor. Judge Yates?
Madam Chair, a point of clarification before I vote. You suggested that there be further discussion about this in executive session. I just want a clarification that this won't be, the vote here today won't be considered a final vote on that, and that you're offered to discuss it further later as part of the Rules Committee is still on the table.
It's up to you.
My understanding is that we are voting right now on Commissioner Levine's motion, which is to proceed to record our executive session. So,
right. But what I'm asking is, in your mind, is this a topic for the Protocol or Rules Committee subcommittee later, or does today's vote take it out of that realm?
I certainly think that there would be additional conversation that would need to happen with respect to whether or not we can do that under any rules that govern how the commission acts, as well as operationally how we would actually get that done. And so those were the conversations that I thought we needed to have before we voted on actually doing it. So it's not clear to me sort of, where those conversations can take place. Certainly can happen there, but I would prefer that the conversation happens before we vote on it.
Okay. Well, on the reliance that this does not preclude further consideration, I vote no.
Thank you, Judge. And Chair Varley?
No.
1, 2, 3, 4, 5 in favor. Motion fails.
Thank you. Is there
Madam
any
Chair?
other?
Yeah, I'd like to. Okay, I voted no because I thought this should be have further consideration. Therefore, I'm going to move that this issue be sent to the Rules Committee that you're establishing for further discussion.
I'll second that.
Thank you, Judge Yates. Is there any discussion? Okay. All in favor of moving a discussion about this to the Rules Committee, please raise your hand.
I see all in Albany. I see Commissioner McNamara, Judge Yates, Commissioner Deering, Judge Newton, and Judge Braun. Commissioner Cohen?
Yes.
Commissioner Deering?
Yes.
Thank you. Commissioner Horowitz?
No.
Commissioner Jacob?
Yes.
Commissioner Levine?
Yes.
Judge McCarthy?
Yes.
Commissioner McNamara, I think I recorded you. Judge Newton, I recorded you. Commissioner Weissman, Judge Yates, I recorded you, and Chair Varlack. So that is 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Motion carries.
Thank you. Are there any other items under new and other business?
12, I apologize.
At this time, may I please have a motion to move into executive session pursuant to Executive Law, Section 9419B?
So moved, Fisher.
Thank you. Can I have a second?
Second, Deering.
Thank you. All in favor?
2, 3. Braun, Cohen,
Yes.
Jacob,
Yes.
Fine,
Yes.
McCarthy.
Yes.
I think that's everyone. Motion carries, ma'am.
Thank you. Walt, can you please let us know when we're in executive session?
Yes, stand by.
This meeting is being recorded.
We are back in public session.
Thank you very much, Walt. General Counsel Stam, can you please report out on the actions taken in executive session?
Sure. The commission discussed litigation matters. The commission commenced one substantial basis investigation. The commission authorized steps in several other investigative matters and in several investigative matters and discussed several other investigative matters.
Thank you.
That was it.
Can I please have a motion to adjourn the meeting?
Moved.
Second.
Seconded, Fisher.
All in favor?
I see 3 in Albany, and I see McNamara, Yates, Deering, Bill.
I got you.
Ron, Jacob,
Yes.
Line,
Yes.
McCarthy,
Yes.
and if Judge Newton is still there. Judge, can you give me a thumbs up to adjourn? Newton, there we go.
There we go.
Is that a thumb? I hope so. We're out, ma'am.
Okay, thank you.
All right. See you, everybody.
Take care.